My name is Tracy George. I'm a professor in the law school and a professor of political science, and it is my great pleasure to welcome you to Vanderbilt University's Constitution Day event. Today's event is made possible by the Hyatt Fund at the law school, and in particular, three student groups I should mention: the Vanderbilt Law Review, the Vanderbilt Law Republicans, and the Vanderbilt Law Democrats. It is particularly my great pleasure to welcome you to today's event because of my opportunity to introduce New York Times reporter Adam Liptak, who's going to speak on the Roberts Court in the Obama era. Adam has been the Supreme Court correspondent for the New York Times since fall 2008, when he took over for the formidable Linda Greenhouse, who had covered the court for nearly 3 decades. Not an easy task, given both the role of the New York Times as a source of information about the Supreme Court, as well as the achievements of Ms. Greenhouse. But Adam not only has continued the great success of the Times, but brought a unique perspective and exceptional skill to his role. He not only secured the Times' position as the source for reporting about the Supreme Court, he also has expanded its role and its influence. Adam's perspective is unique because he simultaneously and seamlessly combines the perspective of a lawyer and the perspective of a reporter. Adam is a real lawyer's lawyer. After graduating from Yale Law School, he worked at Cahill Gordon for 4 years, where he developed a specialty in First Amendment matters. Then he moved on to be in-house counsel at the New York Times Company. The New York Times Company is a media corporation that holds many newspapers in addition to the New York Times. While there, Adam specialized in defamation, privacy, and news gathering issues, and litigated both commercial and media litigation cases. During his decade in the Times legal department, he earned recognition as a leading newspaper reporter, both for his work as a newspaper professional and for his coverage of First Amendment issues, or defense of First Amendment issues, and won accolades for his work on behalf of a free press. But at the same time, Adam is also a dyed-in-the-wool reporter. He deferred law school for a year to spend that year as a copy boy at the New York Times, where he published several pieces and also assisted in the coverage of a landmark libel suit, a subject that would become his focus as a lawyer. While working full-time as a lawyer, he nevertheless found time to publish book reviews, essays, and thought pieces in newspapers and periodicals. He moved full-time from in-house counsel to the staff press room in 2002 when he took over the legal beat for the New York Times, a post which he has described as granting him great leeway to follow the story. He wrote several highly influential series, in particular, a series examining the death penalty in American states, especially in the state with the highest death penalty rate at the time, Texas, in addition to a series examining campaign contributions in the judicial election system common in so many states. In 2007, he created a Sidebar column, which is published regularly, and in 2008, as I said, he took over Supreme Court coverage. Adam's work is marked by several talents. One is his clear talent as a writer. But from my own interaction from Adam, I also would remark on his capacity to weave together many disciplines and perspectives into his writing. He has drawn on and critiqued leading empirical scholarship on the court and other legal institutions. He also has contributed to that empirical work with studies of judicial appointments to the court, the role of clerks, the background of the justices, and the ideology of the justice is a topic I imagine that he will touch upon today. Adam is able to bring, in addition, incredible talent as a writer. For those of you who've had me as a professor, you know my fondness for skilled legal writing and how rare it is. You can read almost any piece by Adam and have the pleasure of discovering a narrative that is clear, informative, and interesting to read. But there is one piece that Adam wrote, he's going to know which piece I'm going to draw attention to, which is a piece he wrote shortly before he went to law school that I want to take a minute to quote because it's so well written. The title of this piece, Plain Air Guitar. When I hear a song on the radio that I really like or that used to be a favorite, I sometimes dance around a little bit and pretend to play guitar. I play air guitar. I remember summer dusks in anticipation of parties, This at a time when a party was a promise of wonder, of a life transformed, climbing out of the shower, the evening's first beer lodged precariously on the soap tray, and hearing the perfect song. Here was pleasure, a long swig, a half turn of the volume knob, the hallucinatory rush of adrenaline, followed by mindless dancing around in front of the fogged up mirror. But more seriously, I would note about Adam that he has brought to contemporary legal reporting and commentary a deep sense of how the law and legal institutions operate, as well as the perspective of a journalist thoughtful about informing and educating the public on the most important issues facing us today. And it is with my great pleasure I now turn over to Adam Liptak.
Thank you, Tracy. I admire your deep research. As for the balance of that introduction, it reminds me of something Justice Scalia likes to say when he gets a particularly fulsome introduction. He says, "God, I wish my parents were here. My father would have liked it and my mother would have believed it." So I was thinking about what I could bring to the topic of the Supreme Court, which is so rich and varied that might have some particular interest and impact here in Nashville, and I was toying with it on the plane, and it finally occurred to me, of course, the one part of the Supreme Court that doesn't get nearly enough attention is the Roberts Court revolution in the citation of popular music. I understand this is a big music town. Now, Chief Justice Rehnquist, who died in 2005 after 33 years on the court, liked light opera, and he wore robes with stripes inspired by Gilbert and Sullivan. That was then. Chief Justice Roberts broke new ground a couple of years ago by quoting Bob Dylan. "From where I sit, his robes remain plain and black." The Dylan citation came in an achingly boring dispute between payphone companies and long-distance carriers. 4 pages in, the Chief Justice put a song lyric where the citation to precedent usually goes. Here was the proposition, and you should now pity me because I spend my days reading sentences like this one. "The absence of any right to the substantive recovery means that respondents cannot benefit from the judgment they seek and thus lack Article 3 standing," the Chief Justice wrote. Then, you would expect a case citation to follow, he wrote this: "When you got nothing to lose, Bob Dylan, like a Rolling Stone, Highway 61 Revisited, Columbia Records, 1965. So I consulted Alex B. Long. He does empirical research like Professor George, but at the University of Tennessee, and asked him to put this in context for readers of the Times. Professor Long is perhaps the nation's leading authority on the citation of popular music and judicial opinions. He said this was almost certainly the first use of a rock lyric to buttress a legal proposition in a Supreme Court decision. It's a landmark opinion, he said. By the way, according to a study by Professor Long published in the Washington and Lee Law Review in 2007, Bob Dylan is by far the most cited songwriter in the lower courts. He's been quoted in 26 opinions. Paul Simon is next with 8, 12 if you count Simon and Garfunkel. And Bruce Springsteen has 5. I can't help but tell you, I have a column tomorrow involving an American citizen infant deported by the Border Patrol who finally gets back together with her mother. And I wrote in the piece, I thought fairly cleverly, "The mother and child reunion didn't go well. Mother and child reunion," reference to Paul Simon. Copy editor changed it to "the reunion of mother and child." And I said, "Well, didn't you think that was kind of fun?" And she said, "What song is that? Haven't heard that song." So we put it back. Look for it. I think it's going to be okay. Chief Justice Rehnquist did cite his beloved Gilbert and Sullivan in a 1980 dissent from a decision that, as a press lawyer, I used to love and cite all the time. The majority said that we have a constitutional right of access to court proceedings, that the First Amendment guarantees the press the right to be able to go to court proceedings and report, except for exceptional circumstances. Rehnquist, then still an associate justice, thought the court had made up that right out of whole cloth. Maybe it did. And to make this point, he relied on the Lord Chancellor in Iolanthe to rebuke the majority. The law is the true embodiment of everything that's excellent, he quotes the Lord Chancellor as saying. It has no kind of fault or flaw, and I, my lords, embody the law. That made Justice Rehnquist's point pretty well. The Roberts citation, I have to say, is more problematic. On the one hand, he showed excellent taste. Like a Rolling Stone, as Greil Marcus has written, is the greatest record ever made, or perhaps the greatest record that ever would be made. On the other hand, Chief Justice Roberts got the citation wrong, proving that he's neither an originalist nor a strict constructionist. What Dylan actually sings, of course, is when you ain't got nothing, you got nothing to lose. Now, it's true that many websites, including Dylan's official one, reproduced the lyrics as the Chief Justice did, and his clerks no doubt found for him. But a more careful Dylanist might have consulted his iPod. Last year, Justice Alito, who joined the court in 2006, went to Chief Justice one better. In a case concerning a fringe religion called Sumum, which wanted to put up a monument to its 7 aphorisms next to a 10 Commandments monument in a city park in Utah. One of the issues in the case was whether the 10 Commandments monument conveyed a religious message. It's the kind of thing you guys will study about. Justice Alito, who must have taken some French literary theory in college, tried to demonstrate that it did not. But he's a lawyer, so he used an analogy. Here's how he put it. What, for example, is the message of the Greco-Roman mosaic of the word imagine that was donated to New York City's Central Park in memory of John Lennon? Some observers, Alito goes on, may imagine the musical contributions that John Lennon would have made if he had not been killed. Others may think of the lyrics of the Lennon song that obviously inspired the mosaic and may imagine a world without religion, countries, possessions, greed, or hunger. Justice Alito then dropped a footnote quoting the complete lyrics of Imagine, took up a bunch of space, and concluded, Jay Lennon, Imagine, on Imagine, Apple Records, 1971. Now, John Lennon has been dead for just about exactly 30 years, but I think he would have been surprised to see his song, which includes the lyrics, and no religion, too, to support a ruling that ended up making distinctions among religions. Now, Justice Alito may be right that you never can really tell what a set of words means, but that's a curious position for a judge to take. Judges, after all, spend their days making pronouncements about what statutes and the Constitution mean. Now, this last term, there was another interesting, notable Alito development. He seemed to have developed a fixation with cable television programming. In an October argument in United States against Stevens, which was a case about whether Congress can make it a crime to ban trafficking in depictions of animal cruelty, whether you can make it a crime to sell a video of a dogfight, say. He asked whether the government could ban a human sacrifice channel. Quote, I mean, people here would probably love to see it, live, pay-per-view, you know, on the human sacrifice channel. Okay, so that's one channel. 3 months later, in an argument over whether the government owns newly restored beaches that had been threatened by erosion, Justice Alito worried about what could happen to the former beachfront property owners. You could have televised spring break parties in front of somebody's house, Justice Alito said. So we have the human sacrifice channel, the spring break channel, $1 million idea after the next, coming from Justice Alito. But back to music. This last term, I'm sad to say, yielded only a single example of a popular music citation. It was in a concurrence by Justice Scalia in a unanimous decision allowing a government employer to inspect text messages sent on official pagers. Justice Kennedy wrote the majority opinion, and it was unusually fuzzy. Justice Kennedy said technology is changing so fast that the court should not be issuing categorical rulings in this area. And I guess if you think about it, given that it involved pagers, the law is probably moving faster than the facts. But Justice Scalia doesn't like it when someone doesn't issue a categorical rule, and he wrote this: "The times they are a-changin' is a feeble excuse for disregard of duty." Now, there was no citation, but I say let's chalk one up for Bob Dylan one more time. Now, Justice Elena Kagan's tastes in music and her propensity to cite unconventional material in judicial opinions is not known, although I do give her some credit for not taking the easy way out when she was asked at her confirmation hearings about the citation of foreign law. She said, you can cite a law review article, it's obviously not controlling what the Supreme Court of Israel say, but to somehow take that one body of knowledge and say it can't be cited when perhaps it has ideas for people she seemed to think was a good idea. I don't know where that leads us in the popular music area, but she didn't seem to be all that shy about citing unconventional materials. What we do know for sure is that the Roberts Court is about to be reshuffled yet again. There were no changes in personnel in the last 11 years of the Rehnquist Court, which is the second longest period of stability in the court's history. In just the first 5 years of the Roberts Court, we've welcomed 4 new justices, starting with the Chief Justice, then Justice Alito in 2006, Justice Sonia Sotomayor last year, and now Justice Kagan. That's a dizzying pace of change. The justices will often tell you that they find it uncomfortable, that every time a new justice arrives, there's a new court, and it's hard for them to assimilate the interactions of one, to say nothing of 4 new people. It's also hard for us journalists because they keep moving around on the bench. We of the dwindling press corps get pretty good seats for Supreme Court arguments. We sit right up front, off to the left. That means that this last term we were quite close to Justice Alito, the second most junior justice, and across the way from Justice Sotomayor. Come the first day in October, all of a sudden, we're going to have Justice Sotomayor over here, Justice Kagan way over there. Justice Kagan will also take on the duties that the junior justice has to do. When the justices meet in their private conferences to discuss how they're going to vote on the case, all by themselves, no clerks, if someone knocks on the door, it's the junior justice who has to get up and answer the door. And Justice Breyer, who I think you've seen has been everywhere lately, had that role through that 11-year period. And he said basically it's reading glasses or coffee or something somebody forgot. We also, as journalists, get very little by way of privileged access, and we're left, let me say one more thing about what the junior justice's job is. Apparently you have to throw a party for the person coming on the court. So it's the junior justice's job, now Justice Sotomayor, to throw a party for Justice Kagan. And Justice Breyer was in charge of the Alito party. Now, I guess the Chief Justice had come in between, but he's never junior, he's always senior. So Breyer remains the junior justice for purposes of the Alito party. And they have a very nice get-together. I don't know exactly where, but I do know this, that as dessert was being served, Justice Alito, huge Philadelphia Phillies fan, the Philly fanatic, the mascot, turns up and gives Justice Alito a big hug, which he found very moving. And he was later heard to remark that this was his second encounter with the fanatic. Once he'd thrown out the first pitch and he met the fanatic on the field, and he said on the field he had a very pungent aspect. There was a kind of a sweaty odor to the fanatic. But here at the court, he said, the fanatic either had his suit dry cleaned or he has a traveling suit. So anyway, we journalists get little by way of public access, and we're left to make sense of the court almost solely through its public acts, of which there are many. And people always want to know what secret thing is going on inside the court. Well, the court hears arguments in public, explains itself at incredible length, and is in many ways the most transparent branch of government. And this is lately supplemented by public statements from the justices, who are sometimes everywhere, and the voluminous and often quite good scholarship the court attracts. But still, it means that I practice, for the most part, not journalism in the usual sense, or the journalism I did in the first 6 years as a reporter at the Times. When I started in the newsroom covering the law more generally and running around and trying to find stories that I had uncovered, and that, the agenda was not being set by 9 old people in robes, but you try to find the story that's yours. I remember asking a colleague, Sam Dillon, what I was supposed to do. It was my first morning, and I'd written essays and book reviews, but I never reported. He said, don't worry, it's easy. Here's what you do. You call people up on the phone and you write down what they say. And that's a pretty good description of what my old job was, which was covering the law on the national desk of the Times. But the usual tools of journalism are of not much use in the Supreme Court. Covering the court is a sort of low-rent scholarship composed on punishing deadline and often compressed into 700 or 1,100 words. That's not much. It's written for at least 2 audiences, each quite demanding in its way. One is made up of specialists who rightly expect of the Times accuracy, doctrinal context, and a sense of the consequences of a given decision. And if you have any ego, you don't want those guys to think you're a dope. You want to try to add some value even in those elite circles, but you have to do it without losing accessibility and a conversational quality, because the other readership is an educated readership that follows the court only lightly, but it cares deeply about it, and this includes a lot of lawyers, I suspect some law professors, probably some law students. These readers want articles that are accessible and that don't get lost in the weeds. It would be hard work either way, but satisfying the two constituencies simultaneously is a constant challenge. Now, let me add a heretical notion. I'm going to use an analogy. The Supreme Court is to the judiciary as the death penalty is to criminal justice. It's very important, but as a matter of proportion, we spend far too much time thinking about it. We execute perhaps 50 people a year and have 2 million people in our prisons and jails, almost 10% of them serving some form of life sentence, and yet all the attention goes to the death penalty. You occasionally hear, and this is not apocryphal, someone being convicted of a capital crime who contends he's innocent saying to the jury, please sentence me to death because otherwise no one will ever pay attention to me again. I won't get the attention of the pro bono bar. I won't get the attention of the habeas court. No one will care if I'm serving life. The only way I have a shot is if you please sentence me to death. The Supreme Court decides perhaps 70 cases a year, only a handful of them of real consequence. Meanwhile, the real work of the law proceeds in our state and federal courts. And the press, as you know, is under a ton of pressure, but the coverage of the court remains extremely strong. My colleagues in the press corps are very accomplished journalists, and I think the Supreme Court is exceptionally well covered. At the same time, the federal courts of appeal and the state Supreme Courts, coverage of them has gone off a cliff. And I get complaints, justifiable complaints, from judges all the time that the press isn't covering where the real work affecting real people all the time happens. And I think that's sad, and it's a consequence of an over-allocation of resources to the Supreme Court, because God knows why everyone seems to think it's sexy. I also labor under the belief that it ought to be okay to have a little fun. The court takes itself awfully seriously, and for good reason, as its power flows almost solely from its prestige. But that's the court's problem, not mine. I think there's room for a little mischief. There's an airless quality to the court's work sometimes, a crabbed quality that does not do justice to the richness and variety of real life. Once in a while, even the justices themselves acknowledge this, as when Justice David Souter did not long before he announced his retirement last year. Justice Souter did not much care for official Washington, and you didn't see him on book tours or ceremonial dinners or panel discussions or law schools. He said he had the best job in the world in the worst city in the world. But he turned up at a session of the American Academy of Arts and Sciences, and he was heard to say this. He said, I find the workload so great that when the term of court starts, I undergo a sort of annual intellectual lobotomy, and it lasts until the following summer, when I cram what I can into the summertime. He was referring to reading real books as opposed to briefs. And you know that Justice Souter has moved back to New Hampshire, where he had to buy a new house because the old one was collapsing under the weight of his books. Now, usually the biggest decisions of the term arrive in June, but this last term, I'm sure you know, was different. The court decided Citizens United in January. Citizens United was easily the most important case of the Roberts Court, and probably the biggest case since Bush v. Gore in 2000. Citizens United held 5-4 that corporations and unions have a First Amendment right to spend unlimited sums in support or opposed to political candidates, independently of them, but nonetheless to support or oppose them. The decision itself is awfully rich, full of nooks and crannies and echoes, and I wrote a ton about it at the time. I wrote a front page piece, the banner headline, perhaps the only one in my career. Then I did an analytical piece about what the decision tells us about Chief Justice Roberts' commitment to judicial minimalism. And I did a column on the bitterness and weariness and disappointment in Justice Stevens' dissent on the bench, from the bench, and over 90 pages of writing. That was also a day when Justice Stevens, even at 90, ordinarily very sharp, in many ways the best questioner on the court. He would save the killer question until the very end. And it was the rare advocate who had a fully satisfactory answer, and he was often able to convey to his colleagues what the flaw in the position that Justice Stevens did not want. But nonetheless, that morning in Citizens United, I believe he'd already played tennis, singles. But nonetheless, he was tired, weary, stumbled a bit, and he later said that that was among the decisions, or among the pieces of information that caused him to think that perhaps, yes, it was time to go. It would be easy to write a dozen more stories about Citizens United. One might be about the misapprehension that this was another case in which Justice Kennedy was the swing vote. True, it was a 5-4 decision, and true, it lined up in the classic ideological way. And true, Justice Kennedy was in the majority. But Justice Kennedy is the most reliable First Amendment absolutist on the court, and he's been wanting to do this thing for a long time. The personnel that really mattered here were Roberts and Alito, and the person who really mattered was Alito. It was his replacement of Justice O'Connor that allowed the conservative side to deliver Citizens United. So we've had these 4 changes I've talked about. Only one of them matters. Chief Justice Roberts is not ideologically very different from Chief Justice Rehnquist. Justice Sotomayor, the early returns do not indicate that she's in any substantial way different from Justice Souter. Justice Kagan, we're yet to see, but I would bet that we're not going to see very distinctive voting from what we might have seen from Justice Stevens. But the replacement of O'Connor by Alito has had profound consequences for the court. And this can be demonstrated across a range of cases, but Citizens United is a good example. Justice O'Connor was one of the authors of the majority opinion in one of the cases overturned, McConnell against FEC. And here, just a few years later, you see it going the other way. A second sort of piece I might like to write, but still haven't, is about media corporations. A lot of people get upset by this idea that we've given corporations First Amendment rights. If it's a problem, it's not a new problem. It wasn't created by Citizens United. And among the people upset about this are the editorial page of my newspaper. And it might be easier to sympathize with their position if the New York Times Company were not itself a corporation. And I ask you to think about how it is we distinguish between a media corporation, which I hope you agree with me has a First Amendment right, but another corporation which doesn't. And do we want the government to be making that choice? And is the Times the sort of corporation that gets that right? Is Fox News? Are the parts of General Electric that are news businesses? Is the Huffington Post? Is the Drudge Report? Is Michael Moore? Those are hard questions. Another piece might look at a largely overlooked but very important part of Citizens United concerning disclosure requirements. Citizens United upheld the disclosure requirements there. So one way to think about it is it may be that everyone has a chance to say what they like about political candidates, but it may also be that we would want to know who's doing the talking. And except for Justice Thomas, everyone was on board for that idea. Variations on that theme are going to come to the court all the time. We already had a case called Doe v. Reed, which raised the question of whether you could, through ordinary state freedom of information laws, obtain the names of people who'd signed a ballot petition to try to get an anti-gay rights measure on the ballot. And the argument coming back the other way is no, this infringes on the First Amendment rights of the petition signers because they'd be subject to harassment and retaliation and so on. You saw a similar argument when the court stayed closed-circuit camera coverage of the same-sex marriage trial in California, that by allowing some things to be made public, you would stifle speech because people would be subject to harassment and retaliation. The issue is not yet done. I think the court has to grapple with this quite a bit, but at least as a general matter, without specific proof of that kind of harassment and retaliation, there didn't seem to be a lot of sympathy on the court. And anyway, in Citizens United, the ruling on that point was 8-1. I want to pause for a second to talk about that same-sex marriage case because it had some really odd reasoning in it. It arrives at the court after Judge Walker in San Francisco and Chief Judge Kaczynski of the Ninth Circuit had cooked up a way to let a few more people see what was going on in that very important trial. It was not going out on the internet. The only question, as the case arrived at the court, was whether in a handful of courts around the country where people would go through security, surrender their recording devices, a handful of courtrooms around the country, people could see this trial in progress. And there was a question in the court about whether Walker and Kaczynski had properly followed notice and comment procedure. That doesn't sound like a Supreme Court issue to me. Maybe it does to you. And the ruling was 5-4 that this kind of camera coverage could not be allowed. And part of the reasoning was this, that the people who would testify, who were all of them paid experts and advocates whose views were well known already, would be subject to harassment and retaliation in a trial in a public courtroom that was being transcribed and that was being covered by the news media quite intensely because of the additional increment that some people in Brooklyn would also see it. I guess I'm still scratching my head about the logic of that. It was one of those cases where the court acted very quickly, and they don't always do their best work when they're working very quickly. So you all probably have a lot of takes on Citizens United as well. It seems that every law professor does. I said to a law professor the other day that I really don't know whether Citizens United will unleash a flood of corporate money, but I do know that it's unleashed a flood of op-ed pieces. One thing sometimes gets lost in those pieces. Citizens United was not an easy case, and there is no question that the court could have ruled much more narrowly than it did. The case involved a 90-minute polemical, nasty documentary about Hillary Clinton. It was going to be distributed on video on demand, so you'd go on your little cable box, and if you wanted to see it, you'd find it. They weren't going to charge for it, but it's not the kind of thing that you'd get during a football game. You'd have to go out and find it. And it was financed by a very odd little advocacy corporation. So even as I say those facts, you might be thinking, well, geez, maybe they could have ruled that 90-minute documentaries that you have to seek out are different from 30-second TV ads that we're really concerned about. Or maybe they could have ruled that some little advocacy corporation is different from General Motors. But the court went much more broadly, and perhaps part of the problem was that the government, the case was argued twice. When it was first argued, the government took the position that Congress has the constitutional power not only to make it a crime to distribute such a documentary, but also to ban books. I was in the courtroom. That's a statement that caused, gasps in the courtroom. And yet, again, a thought experiment, what's the principle that allows one and not the other? If you can make it a crime to distribute a 90-minute documentary about Hillary Clinton, why can't you make it a crime to distribute a 400-page book about Hillary Clinton? All of these ideas are in considerable tension with what used to be the conventional understanding of the First Amendment, that if nothing else, it protects political speech from suppression by the government. Elena Kagan, who was by then Solicitor General, Solicitor General is the top appellate lawyer in the federal government, a Justice Department official. She was, turns out, being groomed for a year for a spot on the Supreme Court. And at the re-argument of the Citizens United case, she presented her first argument ever in any appellate court. And I thought she handled it with great ease and charm. She was a former dean of the Harvard Law School, which probably gives you some experience in dealing with difficult personalities, and she almost immediately faced tough questioning from Chief Justice Roberts, who rode her hard through all 6 of the arguments that she presented last year. Kagan did disavow the statement that the government could ban books, and forthrightly too. She says, the government's answer has changed. And she added that the Federal Election Commission had never tried to regulate the distribution of books. Chief Justice Roberts bristled at that statement. He's very quotable in writing and from the bench. He said, we don't put our First Amendment rights in the hands of FEC bureaucrats. Then he pressed her a little more. She was ready to talk about books, and he asked this question, what about pamphlets? And perhaps to your surprise, Kagan said, well, a pamphlet would be different. A pamphlet is pretty classic electioneering. So the Citizens United case, I think, was emblematic of John Roberts' leadership of the court this last term. He pushed quite hard in the areas of core concern to him, which I would say in this last term were campaign finance, gun rights, and criminal procedure, even as he found common ground with his colleagues, including some liberals, on an array of other issues. The Chief Justice was in the majority 92% of the time. That's more than any other justice. That distinction typically goes to Justice Kennedy, but this last year it was the Chief Justice. Now, this was a term where some of the issues that have most engaged it and the public were missing. We only had one decision concerning national security, none about abortion, and none about prisoners held at Guantanamo Bay, Cuba. So it was, in a way, a different sort of term. The court continued to push to broaden Second Amendment rights, now ruling that the amendment's protections apply not only to actions by the federal government, which it did 2 years ago in District of Columbia against Teller, but also to the states and local governments. That decision, also 5-4, also dividing across that very same ideological fault line. And I guess I have a question for you about both that case and Citizens United. And the question is this. The court often talks about how unhappy they are to have 5-4 decisions, and that they like to avoid 5-4 decisions. But I wonder sometimes when you're in dissent whether you don't want the decision to be 5-4, whether you don't want to convey symbolically that there are questions about the legitimacy of the decision. So in Citizens United, I was describing before some ways one could have ruled quite narrowly, let this documentary get off, not say that corporations have the right to spend whatever they like to elect or oppose candidates. So you could have had a decision that was 9-0 in favor of the filmmaker, the film distributor, but 5-4 on the rationale. I suspect not every justice wanted the headline to say the court rules 9-0, whatever. Similarly, in the question of whether we incorporate a Second Amendment right against the states, it would at least be plausible to say, I was in dissent last time. I think Heller was wrongly decided. I don't think there is such a right. But now that it's the law, I'm not going to say this is essentially the only part of the Bill of Rights that doesn't get incorporated. And so, assuming Heller is correct, I'll go along with it. Again, you could have had a 9-0 decision, not a 5-4 decision. And I wouldn't be surprised if there are some calculations sometimes which go against the usual thinking that we want to avoid 5-4s. Maybe sometimes in dissent, if you want to send the signal that it's not a decision that should be viewed as fully legitimate, you want it to be 5-4, even though in a sense it would be fairly easy to make it 9-0. This last term, the justices further limited the rights of criminal defendants, which is a project that John Roberts was embarked on ever since he worked in the Ed Meese Justice Department. Even then, he wrote memos, perhaps representing only the views of his client, hostile to some of the Warren Court revolution in matters of criminal procedure. Last year, the court narrowed earlier decisions on the exclusionary rule, which bars the use of evidence obtained through police misconduct. And this year, the court moved to focus on the Miranda Rule, issuing 3 different decisions. Miranda, of course, requires the police to warn suspects in custody of their rights before interrogating them. In these 3 decisions, the court first of all allowed local officials to vary the language of the warning. You're used to hearing it in precisely the same terms on television, but the court has never specified that you have to use those precise terms, and they were okay with Florida using different terms. They said that it was proper to, in order to invoke your right to remain silent, that you had to speak up. Which people had a lot of fun with. So you have the right to remain silent, but the right doesn't attach unless you break your silence to invoke the right to remain silent. And they also ruled that after the passage of some time and after a suspect has been released from custody, it's okay to resume questioning. So in all those ways, I think it's fair to say that the court chipped away at the Miranda Rule. Now, Chief Justice Roberts did, though, sometimes somewhat surprisingly, join the more liberal justices not infrequently. He provided a 6th vote in the decision banning life without parole sentences for juvenile offenders, though he went on narrower grounds than the majority. You remember that a couple of years ago, the court ruled that you can't execute juvenile offenders. You can't execute people for crimes they committed under the age of 18. The question now was whether you can sentence them to life without the possibility of parole, whether you could take away from a 13-year-old, say, all hope of ever going to a parole board and saying, I'm a 50-year-old man now, I think I've changed, I think you at least hear me out, let me have a chance to explain myself. And here the liberals, joined by Justice Kennedy, applied that same rule to life without parole, at least where the crime does not involve a killing. The Chief Justice joined, but on a narrower ground, but I'm not sure I should say narrower. There are people in the sentencing community who quite liked his rationale, which was only, judges should always take youth into account. Not only in these cases, but all cases. And that's a proposition that some people might rather have than the one we got from the court, which only said there ought to be some realistic chance, some way, somehow, to go before a parole board. It's not clear how much benefit that's going to provide for juvenile offenders serving life without parole. Whereas the proposed rule from Chief Justice Roberts at sentencing might have made a difference. Roberts was also the only justice to join every part of Ruth Bader Ginsburg's majority opinion, casting doubt on the conviction of Jeffrey Skilling, the former Enron executive. You may remember we had a trio of cases on a law that federal prosecutors love because it's so vague, that says you can't deprive people of your honest services. So in political corruption and corporate fraud cases, prosecutors like this, because no one really knows what it means to deprive someone of honest services. And an argument, what if I'm supposed to be working and shopping on eBay? What if I call in sick and go to a baseball game? And you know, the arguments at the margins. But anyway, the court dramatically narrowed that law, limiting it to bribes and kickbacks. And my point with Roberts was that he was the only one to join every part of the majority decision by Justice Ginsburg. He also joined the court's more liberal members in Justice Breyer's majority opinion, affirming a congressional power to authorize the civil commitment of sex offenders. So someone is convicted of the crime, a sex offense, serves out that crime. There are people who contend that that individual remains dangerous. Does Congress, not the states now, does Congress have the constitutional authority to keep those people locked up on the civil theory that they remain dangerous? It was a little surprising to see Roberts there, particularly when, and this is the least obvious thing in the world, that case, Comstock, may tell us more about how the health care bill will go than anything else, because it had a fairly expansive view of congressional power. Chief Justice Roberts does not seem to be wedded to a single judicial methodology like originalism and textualism, which are the touchstones of Justices Scalia and Thomas. Those two justices, by the way, voted together 92% of the time, which is the highest of any pair of justices. And they often take positions, and I'm not sure I could say this about any of the other justices, or not consistently. Scalia and Thomas often take positions that seem to be in some tension with what might have been their policy preference had the case come before them in a different setting. So in cases concerning sentencing and the right to confront witnesses against you, the Confrontation Clause in the Constitution, you will see them on originalism grounds coming out in a way helpful to criminal defendants. Chief Justice Roberts and Justice Alito, by contrast, can appear more pragmatic. There were more surprises and unusual alliances in this term than in most recent ones. Justice Stevens, for instance, joined the court's 5 more conservative members in voting to uphold a provision of a law that made it a crime to provide even benign and intangible aid to foreign terrorist organizations. Let me unpack that a little bit. There's a law that makes it a crime to provide material support to terrorists. Okay, sounds reasonable. State Department has a list of organizations it says are terrorist organizations, about 50 of them, and probably few of you would quarrel with the idea that it can be a crime to forbid giving money or bombs or weapons to a terrorist organization. But what if you want to give them advice? What if you want to give them advice about how to resolve their differences in peaceful ways? What if you want to sponsor a forum for debate? What if you want to represent them in court? What if you want to publish their op-ed piece? Those questions, much harder, and yet the statute seems to reach them because it prohibits advice and training and expert assistance and personnel, or words to that effect. And here the decision, 6-3, was that the perceived need to combat terrorism was powerful enough to overcome what the court recognized was a significant First Amendment right. It did stress that what's being prohibited was coordination with the terrorist group. So as in Citizens United, the independent speech, you can say whatever you like, Chief Justice Roberts said for the majority, but you can't coordinate with the group. There were 3 dissents, and the surprising bit perhaps was that Justice Stevens signed on to the majority. So it's the conservatives, Kennedy, Stevens. On the other hand, Justice Stevens was never all that great on speech cases. He wrote the majority opinion in Pacifica, the 7 dirty words case, the George Carlin case, and he voted to uphold a statute that made it a crime to burn the American flag. And he was also very self-consciously a member of the greatest generation, an authentic patriot who took military service seriously. And in his Citizens United decision, and I think he probably had to explain the reference to his clerks, he said, well, you wouldn't have allowed Tokyo Rose to say whatever she wanted to say. Justice Sotomayor's replacement of Justice Souter last year turned out to do almost nothing to alter the court's ideological balance. She voted with Justices Ginsburg and Breyer 90% of the time. Some liberals had feared that her experience as a prosecutor would make her skeptical of some claims from criminal defendants, but she voted in a reliably liberal direction in those and other cases. Her first major dissent was in a case narrowing Miranda rights, the one about speaking up to invoke your right to remain silent. And she wrote a quite vigorous dissent in that 5-4 decision. Similarly, the replacement of Justice Stevens with Justice Kagan, who's only 50 and has never served as a judge, will in all likelihood do little to affect the voting lineups on the court. Justice Kagan did do something interesting, and it's hardly unprecedented when a new justice comes on, but I think it's still telling. She hired, of course, 4 law clerks in short order. 3 of them had already clerked for Supreme Court justices. 2 of them for the leaders of the liberal wing, Justices Breyer and Ginsburg, so that is some signal of where Justice Kagan may be aligned. And the 3rd for Justice Kennedy, and I think all insights into how Justice Kennedy might be thinking are welcome in anyone's chambers. It's probably everybody should start hiring Justice Kennedy's clerk from last year. But the departure of Justice Stevens nonetheless represents a real turning point. The court is losing a bit of a maverick who is often skeptical of government power. He was on the court for 35 years, and that matters across many dimensions. Seniority matters at the court. Knowing the law, the personnel, the cases, the institutional history matters, and the most senior justice also gets to assign cases in which he is in the majority to assign the opinion writing when the Chief Justice is not. So the dynamic on the court was very much, until recently, the Chief Justice, whether it was Roberts or Rehnquist, and sitting right next to him in the most senior spot, Justice Stevens. So in a way, the advocate would simultaneously be addressing the 2 people who might be leading the argument back in conference. The most senior justice also speaks second at conference. When the court circulates lists of cases to be discussed at conference, the practice often was that the Chief Justice would circulate a list and then Justice Stevens would circulate a list, and very few people added to that. So for all those reasons, losing that person who had earned the respect and affection of his colleagues with someone brand new means that it will for sure take some time for Justice Kagan to find her feet, and take quite a long time to assume anything like the stature and influence of Justice Stevens. So that replacement, while I said it probably doesn't matter ideologically, in another sense it does. It probably makes the more liberal side of the court yet weaker. I think we're entering a period of stability on the court. It's true that Justice Ginsburg underwent surgery for pancreatic cancer last year, prompting speculation that she might consider retirement. And she just lost her beloved husband, Martin Ginsburg. But Justice Ginsburg, who's 77, didn't miss a day on the bench after her surgery, and was on the bench the morning after her husband died to announce a decision. She's maintained an active public schedule. She's telling everybody she intends to continue to serve for some time. And I think we may well have seen the end of this intense shuffle, barring further health issues with Justice Ginsburg or anyone else. We might be entering a period of stability. On the other hand, there are doubtless those who are at least wondering whether Justice Ginsburg ought not consider retiring if she wants a Democratic president to appoint her successor. If she were to do that, she should probably do it next year, not the year after. The year after is an election year. Or perhaps she's optimistic about President Obama's chances. The quality of the legal work presented to and emanating from the Supreme Court is of exceptionally high quality. But it is, even by the standards of legal writing, lacking in verve and humanity. It doesn't have any of that air guitar quality to it. You and I can think of exceptions, of course, but not many. And I'm sad to say that perhaps except for that Miranda dissent, Justice Sotomayor has brought a somewhat bureaucratic writing style to the court. Elena Kagan's judicial work is unknown. Her academic writing, I kind of liked. I read it all. There wasn't a ton of it. She did mostly First Amendment and administrative law work. I thought it was lively and conversational, deeply engaged in the doctrine, very smart about manipulating ideas across 3 dimensions at once. And I don't think she'll have any trouble keeping up intellectually. And I think she might also, from that experience at Harvard Law School, find ways, not through horse trading and personal charm, although she has a great deal of it, but through finding smart ways to appeal to things that matter to people in the first place. I think she might find ways over time to forge coalitions. And I guess I have to say that when this always happened on a Friday afternoon at 4 o'clock when when the administration dumped the documents from her time in the Clinton administration. Some of those had, shall I say, a pungent quality to it. She could be a fairly tough customer, particularly to subordinates. Linda Greenhouse, who you heard mentioned, preceded me as the Times' Supreme Court reporter and covered it with great distinction for almost 30 years. And she gave me this good piece of good advice. I think this is good advice for you guys too. When I started the job, she said, always read the dissent first. The dissent will tell you what's really going on. The majority opinion, and this is in the nature of legal writing, adopts this rhetorical pose. Modesty, inevitability, we are constrained by the statute, we're constrained by the precedent to do whatever. It says the result was compelled by the routine application of settled principles. Nothing to see here, move along. The dissent, if it's a good dissent, says, wait a minute. The best dissents are written by the court's best writer, easily the best writer, Justice Scalia. You may not be persuaded by what he says, but you will feel confident that he has not overlooked any flaws in the majority opinion. Justice Alito, though less flamboyant, is also very effective in this way. On the left, for the most part, you seem to get a different kind of work product. To my mind, it's often a shadow majority opinion, what the majority would have looked like had the dissent managed to attract 5 votes. The two opinions, I find, sometimes seem to talk past each other, don't have this level of engagement, which is, you know, fun for a journalist because we love conflict, but also valuable because it shows you what the dissent thinks is wrong with the majority, not only making the case for its side, but, you know, sort of critiques and probably keeps honest the majority. Chief Justice Roberts is a very good writer too, the only first-rate writer on the court except for Justice Scalia. It's a skill he honed as a Supreme Court advocate. He was a very good lawyer, appeared before the court more than 30 times. Sometimes I think he still has an advocate's temperament, a love of scoring points and going for the jugular. At argument, Chief Justice Roberts is quick to correct an advocate about a minor point in the record. And he tangled often with Elena Kagan. On the other hand, he's only 55. He'll have a long run. He may well mellow. He's already shown signs of a welcome playfulness, as the Dillon episode demonstrates. And I think of a generational cultural shift. Last year, for instance, in a dissent from a decision not to hear an interesting criminal case, he described a street corner drug deal in Philadelphia in 2 paragraphs of clipped, hard-boiled sentences that owed something to Dashiell Hammett and Raymond Chandler. The neighborhood, Chief Justice Roberts wrote, tough as a $3 steak. Have some fun. The question in the case, interesting question, was whether a hand-to-hand exchange of cash for a small object in a high-crime neighborhood, whether a police officer seeing that, I hand somebody a wad of cash, they hand me something, is that enough to justify an arrest? The Pennsylvania Supreme Court said no, because the police officer there, Sean Devlin, had not actually seen drugs. In the more conventional part of his dissent, Chief Justice Roberts wrote that there was no explanation for what happened on the street remotely as likely as the drug transaction Devlin believed he had witnessed. In his noir mode, the Chief Justice put it this way. Devlin knew the guy wasn't buying bus tokens. He radioed a description and Officer Stein picked up the buyer. Sure enough, 3 bags of crack in the guy's pocket. Head downtown and book him. Just another day at the office. Well, I thought this was pretty funny. You know, you don't get a lot of candy like that on my beat. And we put it in a little box in the paper. Since then, and I guess I should have been alert to this, I've talked to several public defenders who were offended by the Chief Justice's tone, which they thought was insulting. I think you can ask the question, and this is hardly confined to Chief Justice Roberts, but these are people, almost all of them, have led very cloistered lives, and I don't know that he spent a lot of time on Philadelphia street corners observing the exchange of anything. Anyway, these public defenders thought this was kind of insulting, and I'm sensitive to it because there's a sense in which we in the press encourage this kind of stuff, just as Justice Scalia is rewarded with uproarious laughter every time he makes a wisecrack during arguments. Most of his wisecracks are quite funny. I think maybe I'll wrap up and we'll turn to questions. But I did want to talk a little bit about the justices we have now. All of them, it's a very narrow group of people. a couple of generations ago, not at all unusual to have a governor on the court, to have a former attorney general, to have a United States senator, to have people with big, substantial public lives who brought some of that to the court. We're in a different era now, something Chief Justice Rehnquist complained about, where we're moving almost to the kind of bureaucratized lifetime system of judges that European countries have. So we have people with very, very fancy credentials. More and more of them have clerked on the Supreme Court. Every single justice attended Harvard or Yale Law School. Justice Ginsburg started at Harvard, graduated from Columbia, but all of them attended Harvard or Yale. They're almost entirely from the coasts and almost entirely from the East Coast. Most of them come from the circuits I like to refer to. I wonder if this is a meaningful term to use, the Acela circuit, between Boston and Washington. There is, interestingly, Justice Stevens was the last white male Protestant on the court, and we now have 6 Catholics and 3 Jews, something that would have been unthinkable not all that long ago. But anyway, you wonder if something's not lost by having a greater diversity across many of these dimensions, geographical, background. You don't even have a variety of legal practice, and you can see it when you have former prosecutors like Alito and Sotomayor. They understand the case a little better when it's a case involving prosecutors. When you have a case involving legislative history, Justice Breyer, who worked on the Judiciary Committee, has a better understanding of it. And yet we seem to be cultivating people who go to the fancy law school, mostly work for the federal government, clerk, maybe work in the Solicitor General's office, maybe work in an executive department, and you don't have anything like the range of experience you used to have. We do have, more gender and race diversity than we used to. I don't think there's any doubt that that matters too at conference. Justice Scalia was once asked whether it made a difference when Justice Thurgood Marshall, the first African American and the great hero of the civil rights movement, joined the court. And he gave a candid answer that human experience will tell you has to be so. He said, just having Thurgood Marshall in the room, didn't have to say a word, just having him in the room when the subject of race would arise would cause everyone to think harder about it. And we've all had this experience. It matters. There's a gravitational force where all of a sudden you're seeing it through the other person's eyes, and it matters. And to that extent, some of the other kinds of diversity are probably making a big difference. I've talked for almost an hour, so maybe I'll stop now, and I'll be happy to have your questions. So to review the bidding, the question concerns the exchange at the State of the Union address, where just a few days after Citizens United was decided, President Obama, to the faces of 6 justices in attendance, said the Supreme Court had gotten it terribly wrong. And, arguably mischaracterized what the holding was. Justice Alito, who was not the most media-savvy member of the court, appeared to mouth the words "not true," and that got him some attention too. And so you asked whether that's appropriate. Not for me to say. I mean, in general, I told you before, we like conflict. So great story, good. It's got people in it. It's not some abstract idea, good. I think, as the Chief Justice later said, anyone should say what they like. He also indicated that he might not like to continue going to State of the Union addresses if they turn into what he called political pep rallies, and that's also his choice. Justice Breyer has indicated he's going no matter what he likes to go. So what? I guess I I don't know that I have a problem with any of it. You know, it seemed to be all but unprecedented. You know, I guess Roosevelt said things more generally, but this idea of the case by name to the justices' faces, it was something new. It does seem to be an issue, the Citizens United case seems to be an issue on which most people, and certainly most people inclined to support Democrats, seem to think it was a misguided decision. So politically, it's probably good for Obama. And it'll be very interesting to see who goes next year. It'll be, you know, it'll be hard for Kagan not to go. So then you got Breyer and Kagan. If only the liberals go, is that going to look odd? The calculations that must, you know, probably people spend months puzzling this out. We'll see. Yeah.
I listened to an interview with Justice Scalia, and he talked about writing dissents and how they largely exist for the benefit of law students, and that he tries to keep them as entertaining as possible. So we'll read them. So I was wondering if you might point us in, as you sort of already done, point us in the direction of some spectacularly entertaining dissents.
Oh, what a great question. And I think I'm gonna disappoint you. I don't. Oh, let me think. No, I can't point you to any single one. I'll say this, there's a kind of algorithm to it. The fewer justices who join, the better the Scalia opinion, right? So the reason he likes writing dissents better than majority opinions is on the majority opinion, it's this elaborate process of getting everyone's vote, and as a consequence, it becomes bland and often ambiguous. And even in dissent, sometimes, you know, you might want a couple people joining you and therefore are willing to take out, you know, some of the funniest stuff. But if it's just Scalia, you're almost certainly in for a good time. Yeah.
On the topic of diversity and representing different groups on the court, in the recent case of the 13-year-old girl who was stripped
Yes.
from school, I'm not really sure.
That's right.
Justice Ginsburg pointed out that at the time she was the only woman on the court, and she was able to give some insight into what it was like to be a 13-year-old girl to her fellow members, and she thought that might help the other court members change their vote. Given that there are only at the moment 9 court members, how can we possibly represent all of the groups, and how can we keep the court from making decisions on the experiences of others that they've never had? We're talking about an elite group, but they're always going to be elite in some sense.
So I don't know how well you heard the question. It was a fascinating moment last year. There was a fairly disturbing case involving a 13-year-old girl named Savannah Redding in Safford, Arizona, who was, on the strength of a tattletale, said to be possessing contraband drugs in the form of ibuprofen, which you know is Advil. And they thought she might be hiding it on her body, and they made her strip to her underwear and pull out her bra and underwear and shake it around. And she found it deeply humiliating. And I went out to interview her, and she never went back to that school. Case goes to the Supreme Court, and it's pretty clear at the argument that the men on the court, which is to say 8 of them, just weren't getting it. Justice Breyer, who is capable of saying goofy things, said, well, I used to get changed in gym all the time, and people would put stuff in my underwear. And I was sitting there. It did not seem to me that Savannah Redding had a particularly good shot in court. Justice Ginsburg did a very unusual thing. She gave an interview while the case was pending, before it was decided, to Joan Biskupic of USA Today, a fine reporter and the author of a recent book about Justice Scalia, and said, as the question indicated, that this experience to a young woman would be deeply troubling and humiliating and not, sort of fun. And that seemed to carry the day. And the decision comes out, it was quite lopsided. I forget, 8-1, 7-2, quite lopsided, maybe 8-1. If it's 8-1 in this kind of case, you know who's the one. It's going to be Clarence Thomas. And so the question is, so here's, in that same interview, to digress for a second, Justice Ginsburg said something extraordinary. She said that at conference, she will often say something that the men ignored. A little while later, a man would make precisely the same point, And people say, oh, what an interesting point. Yeah, we should do that. And strongly suggesting that there was a kind of implicit sexism going on even at Supreme Court conferences. So that raises the question. The question was, what can we do with only 9 justices? And I don't think that number is going to change anytime soon. What can we do to ensure more diversity? And your idea is as good as mine. There seems to be popular sentiment in favor of diversity in the sense that we're used to talking about diversity in law schools. So you're probably going to have race, ethnicity, gender diversity. But from a certain slice of life. So I don't know, and at the same, I don't know if you're a senator how to take account of these things. These are hard questions. I don't have a good answer. Yeah.
Talk a little bit about, as a journalist, you're not getting much of the inside baseball. You kind of what the public acts of the court are. Occasionally we'll get books sort of professing to give the kind of under the rope view, like a Brethren, for example. Do you think those books are trustworthy? Do you think they're useful? Do you think we need to know kind of what's going on behind the scenes? Or it's just kind of what the public acts are enough?
Oh, I think more information is good. I don't think it's impossible to get at what happened with the passage of time. And I don't think it's that hard to get at stuff if you allow people to speak to you anonymously, including the justices. So I think Jeff Toobin, Jan Crawford Greenberg, some time ago, Bob Woodward and Scott Armstrong and the Brethren did valuable work. And it's a little hard to verify, which is the problem with confidential sources. But on the whole, people don't seem to dispute the basics of it. There was a very good Vanity Fair piece that David Margolick and others wrote about Bush v. Gore. I think with the passage of a little time and the grant of anonymity, you can get some stuff, and it won't be wholly verifiable, and that's problematic, but I think better to have it than not. You read it with some level of skepticism. If something is profoundly wrong, the people involved will find a way to make that clear. I haven't yet read the briefs closely. There seems to be a thinking in the land that other voucher cases might control this result, that the Ninth Circuit went off track, that the fact that this is cast as a tax credit rather than government spending ought to make a difference. But you don't take anything I just said to the bank, because that's in my to-do pile of things to read. All the way back there. There are lots of theories. The court's docket has come down dramatically in the past 20 years. Used to hear about 150 cases, currently hear about 70 cases. Why is that? And there are a bunch of conventional reasons. There are cases the court used to have to hear as a matter of mandatory jurisdiction. It doesn't have to hear anymore. Congress doesn't tend to, until recently, in recent years, pass big complicated statutes that need a lot of exposition. There were a couple of justices on the court who would grant cert in any circuit split. Were gone. And a leading reason might be the cert pool. Do you guys know what the cert pool is? It's where the justices who participate in it, which is almost all of them, take their 4 clerks each and share them so that a single clerk writes a memo summarizing and recommending a grant or denial of every single cert petition. So one at a time, and that goes to all chambers. And everyone says that you're not going to get in trouble for recommending a denial. But if you recommend a grant in a case that turns out to have problems that needs to be dismissed as improperly granted or something, then you've made a big mistake. And for years and years, everyone with Justice Stevens was in the cert pool. Then Justice Alito a couple of years ago went into the cert pool. But the fact that it seems that one or two pairs of eyes are falling on these 7,000 or 8,000 cert petitions every year, that almost certainly has a hydraulic pressure. And then does it matter? I don't know. I mean, they take a lot of cases that are trivial, and they could take fewer of those as far as I'm concerned. And they don't take some cases that look really cool. They should take more of those. But that's not an absolute number. That's a quality, not quantity point. Yeah.
I'd like to hear you comment on some
I sure read them. I think they're great. The other day, Justice Kennedy seemed to suggest, and this goes back to the cert question, that his clerks read the blogs, and it might influence their thinking a little bit about what kind of cases they should put at the top of their pile. So it seems that the clerks read them too. There are various kinds of blogs, and you know, some are better than others. Some of them are just fun. Some of them are mostly commentary, somewhat ideologically tinged. The ones I like the best are the ones that go deep into a particular subject matter area. So Doug Berman's sentencing law blog, I think, is great. Rick Hassen's election law blog, I think, is great. The patent blog, Patently O, is great. These are people who, in almost real time, give you authoritative and fairly straight insights into fast-moving legal development, statutory, and case law. It's a huge help. Marty Lederman, who was in the who used to be at Georgetown, went to Justice Department, came out and is now heading back to Georgetown, used to write on balkanization in the Bush years about military commissions and so on. He seemed to be able to digest a 100-page statute with revisions in 15 seconds and give you, you know, an authoritative overview. That's great. You know, I wish more faculty did. I hope faculty get credit for it. Yeah.
I'm wondering if we ever hear back from the justices about something you've written, or a case or an issue, or do you think they care about your coverage or the coverage of other newspapers?
Judging from the interactions I've had, they care. Yeah. You hear a little bit, yeah. I mean, they're seldom fan notes.